This is Mike Einspar, and this is my slide presentation on tort liability. What are torts? Torts are a common law jurisdiction in which case someone has suffered loss or harm in resulting in legal liability from someone who commits a tortious act. There are two types of torts. There are negligent and intentional. The intentional tort is where someone has set out to hurt somebody, whether it be verbally or physically. This also involves assaults and batteries. The next kind is negligent, where the person did not set out specifically to hurt another individual, but because of lack of duty, breach of duty, that person ended up becoming injured. The first case I will review is the Nichols versus USD 400, and this is a case where Jeff Nichols was a football player, and practice ran a little late one night, and so practice was off campus, it sounds like their practice facility was, and so they would have to run through a waterway to get to practice and to school. And so practice ran a little bit late one night, running in the dark, and he tripped and didn't really fall, but kind of tweaked his neck and his back a little bit. Didn't really feel it at that particular second, but by the time he got back to the locker room, he felt that he had injured himself. The mother sued based on making the kids run back to the locker room in the dark, and that there weren't coaches spaced along the way. I'm sure the coaches were, in the back. Probably one was in the front, opening the locker room door in the back, and the other coaches were in the back, making sure the facility was cleaned up. Both parties agreed that the coach did not intentionally hurt Jeff Nichols, but it did happen either way. The court ended up ruling for the school district. They did not feel like the coach was at fault or had any kind of a intent or negligent supervision in this case. She was also not able to sue the city or the school district on the grounds that the area that were used was for recreation, and so just because they tripped a little bit, there was no intent there. She couldn't sue on that part either. In our district, a reactive piece of that would be to probably bring the coach in, maybe do a coaching note, or just have a visit with him about starting practice a little bit early, maybe, or definitely ending practice early enough that the kids weren't running home in the dark. Or another alternative would be maybe to find another route to the locker room into the practice field that's not through a waterway that might cause some harms. That would be, I guess, both proactive and reactive. They're finding another way to get to and from practice. Reactively, they're just probably bring the coach in and visit with him about, maybe a little bit more supervision and changing times on his practice. Professional ethics, it's that coach's duty to make sure that those kids have a safe path to and from practice, and that all the coaches that are involved, spread out to make sure that they are supervising those kids while they're underneath their direction. The next case was Frame versus Camus. The facts of the case were that Dr. Camus was he was a certified teacher, but this day he was subbing for another teacher in the class. During the class, Casey Frames, a student, became somewhat disruptive, and when asked to leave the classroom, he would not leave the classroom. Frame slowly stood up. It wasn't like he jumped up and really got in the face of Mr. Camus, but he stood up and confronted Mr. Camus. At that point in time, he felt like Mr. Camus felt like he needed to grab the student's arm and help him on his way out of the classroom, since he would refuse to leave. All at the same time, unintentionally, he trips, hits his head on something, but eventually he is removed from the classroom. The parents filed a suit alleging assault and battery, that Mr. Camus grabbed his arm with intent to harm. He had no right to do that. And the courts favored in Mr. Camus' side, saying that, yes, there might have been an assault and a battery committed at this point in time, but it was for the safety of the class. It was in his educational realm, that it was not over excessive force. He didn't take a chair and throw it at a kid. He grabbed his arm and was trying to help him out of the classroom for the safety of the rest of his class so that education could continue. Reactive, there would definitely be an investigation where you would, as an administrator, you'd come in, you would interview all of the people who were involved in that class and that witnessed anything. You would definitely have a huge talk about anytime you put your hands on a student in an aggressive manner, and probably definitely do some coaching notes there. Proactive, definitely there would be some anger management training on both the student and the teacher on how to conduct ourselves when we disagree with each other. You might even have the teacher go through some MANT training, so just how we can defend ourselves and how we can diffuse situations without physically putting our hands on kids unless it's absolutely 100% necessary. Professional ethics, I think Mr. Camus probably did the right thing here by trying to get the young man out of the classroom in a non-aggressive nature. We always have to remember that we have to keep all students in our thoughts, and their educational is a priority. The next case is Flanagan versus Canton. In this case, this happened during a PE class where in the Canton School District, where during PE the kids were unusually rowdy towards the end of class, and usually they let some things go, I guess, and blow the whistle and let the kids go in and change and get ready for class. At this point in time, to this day, the teacher blew the whistle, brought the kids in, understood that they were a little bit rowdy, and went over the ramifications on being rowdy and how not to be. Then he blew the whistle, let the kids go in and change. At this time, the teacher hung back a little bit to visit with another student or another teacher, and in the course of the 2 or 3 minutes here, while the students were alone in the locker room, Brandon Flanagan became injured from a shoving match that happened in there. The students were temporarily unsupervised during this event, which is a huge issue. Because of the pushing and shoving, Mr. Flanagan received some severe injuries during this event, and at this point the mother sued the Canton School District for negligent supervision. The courts ultimately favored in Mr. Flanagan's favor because they talk about, we can't keep kids safe from every single scenario out there, and that we are responsible when we can see foreseeable things that are happening. And in this case, since the kids had been rowdy, they had been warned, they had been talked to, there is a foreseeable situation that the teacher needs to be responsible for and should have followed the students into the locker room to supervise instead of hanging back for those 2 or 3 moments. Had there not been rowdiness beforehand, had there not been any kind of warning by the teacher, this might have went a different way. But as a teacher, we are responsible for the foreseeable injuries that might happen in a scenario in a school situation. Reactive, definitely you bring the teacher in, you visit with them, you talk to them, you do some coaching notes, and you reiterate that there cannot be times when kids aren't unsupervised, especially after a foreseeable problem like this. Proactively, depending on the class size, maybe we need to get a pair in there to help supervise the transition times. Maybe there needs to be some classroom rules where we wait outside until the teacher goes in, and if the teacher needs to speak with another teacher, they can wait out in the gym until such time happening there. Professional ethics, we definitely owe it to, especially the student that gets hurt, but all students to put them in situations that are positive, where they're not going to be injured, and if this is a foreseeable problem where kids are getting rowdy, definitely need to separate them. The next case is Rollins versus Concordia Parish School Board. In this case, there was a fourth grade student who ended up having her leg fractured by falling off the merry-go-round during PE. It was a situation where we had a substitute teacher supervising around 40 students out on the playground. Mrs. Green, the substitute teacher, realized that the girls who were playing on the merry-go-round were going a little too fast, so she warns them, hey, girls, slow down. And about that same time, the boys who were playing basketball end up having a little argument, so she turns to clear up the argument. She looks back and hears a scream because the girl had fallen off of the merry-go-round. The court sided with the Rollinses on this. They felt that the school did not provide proper supervision, one teacher for 40 students, and they also felt like because the teacher foreseeably saw that the merry-go-round was going too fast, was out of control, that there was a safety issue there, and that she should have went and made the girl stop the merry-go-round before she went and seen what was going on with the basketball game. Now, because of their 50% fault, the Rollins student was found contributory negligent, which means that she was 50% fault and only awarded half of the damages. Reactive, it's pretty tough when you have one teacher out there over 40 kids, and you're trying to keep them all safe. But you talk to them and the students about when teachers give directions, you need to listen immediately because injuries can occur. Proactively, this is a situation where they need to upgrade their supervision staff, meaning they need at least 2 teachers, if not 3 teachers out there on the playground with so much going on to make sure everybody is safe. Professional ethics wise, I think the teacher was doing what she could do with 40 out there. We never want to see kids get hurt, but at this point in time, if that merry-go-round is going too fast, you need to make those kids stop and listen to exactly what your directions are to keep people out of harm's way. The last case is Hall versus Jones. And in this case, Mr. Jones was a PE teacher. He had a game of basketball going on his side of the court, and he had left his area of the court, went to the opposite end of the gym to let another PE teacher know that she was being called to the office. During this time, a fight broke out between students, and as a result, Mrs. Hall's son received some head injuries. She sued the school district for lack of supervision, and 3 teachers were also involved in this. In the end, prior to that, all teachers had claimed that they claimed immunity under the state agency law, that they were working within their duty in their job description for the state, and they were not liable. The court sided with Mrs. Hall because when Mr. Jones left his supervisory position area to go to another end of the court to let that teacher know that she was being called to the office, that was not included in his job description, and he was not working within his duty, his breach of duty there, and the kids were unsupervised, and so the courts found for her. Reactive, this is a thing where you need to bring all the teachers in and talk about when you have an area that you're supposed to be supervising, an activity that's under your control. You need to be there and have control at all times. Proactively, we need to find a different way to communicate to all teachers on if they are being called to the office, and that's always an issue, whether you're using radios or telephones or whatever it may be. Professional ethics, again, we're not necessarily our duty as a PE teacher to get messages from the office to everybody else. If they're close, we try to do what we can, but we also have to remember that the number one priority is our students and their safety and the activity that we are supervising. Thank you.